to say do not operate in motor vehicles and keep away from kids and pets. I mean, that needs to be visible on whatever, comes out.
Well, let's, again, yeah, the various interests. I've asked the two doctors to look into what kinds of things, herbicides, pesticides, and very common kinds of things, the health safety stuff, and then let's bring that information back in terms of a recommendation, and we'll see if we can perhaps add a few paragraphs to address these concerns.
And just go ahead.
Can I throw one more thing into the mix? I'm not sure if this is the appropriate time, but just to kind of go along with your train of thought. Is we had talked last time about potency levels and whether or not that's something that should be required here, and I just want to throw that out there as well as perhaps something that...
I think ultimately we're going to get to that point as an industry, but I don't think it's good to start out with that. Just, I mean, if you got to have labs, you got to have, there's a number of things you got to have.
So that,
at some point.
So just the last clarification, number 4 under B, the patient registry number of the purchaser. That to me is just something that needs to be discussed because of privacy and everything like that. So I'm open to crossing that off.
Okay. Yeah, and again, bring your recommendations back and we'll
okay. I'll just, because sometimes you cross things off. And,
we never did establish a statute for that.
So that's
to have Paul's back, we never did establish the statute for why that actual patient information was on the label.
Yeah.
We never did establish statutory authority for that number.
No, I heard your argument.
Okay,
Jill.
cool. I'm just saying.
If it's there, I'll give it to you at the next meeting. I feel pretty comfortable with it, but I'll bring it to you.
Just saying, to have Paul's back, you never did establish that.
Any other comments on that? Very good discussion. Let's move to page 84. Yeah.
That patient number thing, if we're talking about the product information sheet, that goes to the patient anyway. So it's in their possession, and if they choose to disclose it, they can, but it's up to them. So I don't know if that's terribly important. I mean, it is important, but we can discuss it.
43.313, 43.3313, unlawful financial assistance owner manager. Again, this is another one that we big borrow and stole from other industries that we regulate. It does provide some, by way of example, things that you look at, determine who's an owner and who's not. But I would caution you that you can't just take one specific element and say that that makes that person an owner. It truly is a totality of documents that really drive that bus. And I would give you that, it is somewhat subjective. It is somewhat of a gray area. But in some of the other regulated occupations we have case law out there that drives this. These have been, this template, at least the generic version of it, has been through what's called Rule 106 actions. It's been tested in court and upheld, really is the way that means and what that means. But I took that boilerplate and then the things that are specific to this industry. Certainly if you're guaranteeing the lease, if you're controlling the licensee, guaranteeing their debts, production levels, if you're the beneficiary under their insurance policies, acknowledging liability for taxes, those are all truly indicia or elements of ownership. Very black and white. And so I think this is a fairly good rule. There may have been some things that I missed in here. There may be some things that need to be added, but I'm certainly willing to listen to comments or discussion.
And I'm wondering whether you really need subsection C as it relates to the spouse, because unlike the liquor code, the medical marijuana laws do not require like a separate license necessarily for a spouse. Unless I'm missing something.
No, I see where you're going with that. I guess if they both held licenses, or one held, no, I'm not opposed to removing that. I hear what you're saying.
Yeah, I don't have a great objection to it. I just wonder if it's superfluous.
What if one of these spouses is prohibited from holding a license, for instance, a felony? How does, would that affect this at all? I'm just talking about.
I don't think so, because they couldn't get a license to begin with. Correct.
But the spouse could, there's nothing prohibited.
Well, right, but
You don't have to get divorced.
No, it's probably a good catch.
Yeah.
Nick?
Just so it is, if I am meeting with my grower and say, look, we need to have 10 pounds. Can you do these 10 pounds for us in over X period of time? And I'm saying yes or no, or if there's what he can't do. That sounds like, he's an employee of ours, and that sounds like you're saying that he has a financial interest because he's saying what he can do. How is that possible? I don't understand.
Well, and again, you can't isolate any one single element and say that makes him an owner. It's indicia of ownership.
It's what?
It's evidence of ownership. If a person's coming to you, and I'll create a scenario that I think would be illegal. A person comes to you as a grower and says, I can guarantee you that I'm going to grow X pounds and I want X percent. I want 80% based on X pounds produced. I think that may be evidence that he's probably the owner of the grow, and you're not. And now that's a very broad-based scenario that I just painted for you. But you can't just take that specific element. I mean, you got to look at if the crop fails, who's going to pay for it? Are you paying for it, or is the grower paying for it? The tax liability, the insurance liability, who owns the building, who's got a lease on it if that's the case. I mean, all those kind of things need to be taken into account.
Well, what's missing then, based on what you said there and what's written here, is a dollar figure. You linked production with dollars in what you just said, and this just talks about production, so I'm still...
Well, I didn't. I linked it with possession, I linked it with control, I linked it with financial. Again, you can't just take one specific element of this and say that that makes that person an owner.
So, in a situation where somebody is on a set salary, but has also guaranteed certain levels of production, that situation would look...
Well, I mean, it would be something we'd look at, whether it's unlawful or not, it's the totality of the whole thing, yeah. The reality is, if you're an owner, we're gonna find that out. That's the kind of things that we look at, and I'm just telling you, this is really what we look towards to determine whether or not it's a true ownership situation. It works, it's proven
Now,
itself.
Let me ask this, because this makes me just question. Would one of my employees be able to turn around and say, well, this morning, while Jessica was at the DOR meeting, she left us in charge of making 300 chocolates, and we had to make them. Now I own this company because I get paid $10 an hour to do that. But you know what I'm saying, that this,
But it has to
it can go both ways. If you can hold my people accountable, can they not hold me accountable to the same? I mean, they're guaranteeing me that they're going to make what I set them up to do. I said, here's everything you need to do this.
I think you're missing one thing, but sorry,
No.
but I think what he's saying is that this is only one of multiple things that he looks at in order to prove it. This one,
Right.
this one may be, yes, the grower or the manufacturer may be held to this, but he doesn't meet other qualifications.
No, they don't have anything else.
Right.
But
What's
I'm just
real
saying,
common?
is there any way for somebody, in my situation, my employees don't have much vested interest, but is there a way for an employee who thinks that they have more vested interest than maybe that they may have put into the space, the equipment, all of the stuff for a grow, to turn around and say, well, Bruce asked me to promise 10 pounds, and I promised and I delivered, and now I own part of this business, and what would be the grounds for that, and does this open that door to that kind of set of problems?
It doesn't from a regulatory standpoint.
Okay.
But if conversely, and again, I'll create another scenario, you hire a manager to manage your business while you're gone. Or maybe you're going to move to South Carolina, but you want to keep your business, and you hire a manager. Again, I'm making something up.
I don't like.
But in connection with that, your manager has to have his own sales tax license. He's using his own money in your business. He's guaranteeing the yields. Do you see a problem?
Right, yeah.
Okay. That's, again, a very
Wouldn't the
out of this
manager
world
still be
scenario.
using my sales tax license, though?
No, manager can't use your sales. He could remit taxes under your sales tax license for you. but he couldn't use your sales tax license. There's a difference if he's the true owner of the business and using your sales tax license, or remitting sales tax and owning the business. You see the difference?
Not really, to be honest